Yeah.
Good morning and welcome to our webinar all about how to navigate the changes that are going on in the world of HR and employment law at the moment. My name is Helen Vane and I am founder and director of GoGecko Recruitment, and I will hand you over to Claire to give you a little bit of an intro to her. I've been in recruitment for 25 years and I have experience in both in-house and agency recruitment. So there's not a lot of people stuff that I don't know about. I also do soft HR for some companies as well. So Claire, tell us a bit about you.
I hadn't actually realised. Good morning, everybody. By the way, it sounds like Helen and I are actually very similar ages, but we haven't had that conversation. And I only say that because I've been doing employment law for about 25 years. So I think we're probably very similar in age. Yes, so I head up the employment law team here at Dean Wilson. As I say, have been doing this for what feels like a very long time. And certainly when I see some of the changes that are coming up, I think, oh, yes, no, that's just going back to how it used to be, which makes me feel very old. So I mainly act for employers of all sizes across all industries, do a bit of work with senior executives and other employees as well. But generally, I like to say that I am a specialist generalist, really, as in that I do most, or I have and am able to advise in most aspects of employment law, specifically things like dealing with disciplinary and grievance procedures, performance management, absence management, drafting contracts for employment, staff handbooks, and obviously the more contentious stuff in terms of employment tribunal claims. So, and I also train and do these sorts of talking events on all aspects of employment law. So that's me, really.
I just wanted to say a little bit about housekeeping. We've got some people on camera, some people not. Lovely to see faces. We want it to be super interactive. So if you've got any questions, pop them in the chat and I will be managing the chat so that no question is a silly question. So if you've just got something burning, we'd rather you get it out and answered today. If you think of anything afterwards, we're also available to answer questions afterwards. So I just wanted to set that up as housekeeping. And just, it's, as I've said, an interactive session. So please join in. We want to hear what you think about what's going on in the world at the moment as well. Claire, I'm going to hand over to you. So Claire is very much going to do most of the webinar in the sense of the employment law side of things. And then I'm going to give you a little overview of retention and recruitment and some tips on maybe how to navigate the changes in NI and national living wage, etc., to kind of look at different ways, more creative ways of still growing and growing a business, but also retaining people as well. Claire, over to you.
Okay. Yes. So we've got some slides. I think actually we've done quite a few of them. What we're going to cover. So I'm going to kick off with a bit of a review of sort of where we are, where we may end up getting to in terms of working from home, hybrid arrangements, return to work, or return to the office mandates, the employment rights bill. Whilst I was preparing for this last week, it the bill was going through its third reading in the House of Commons, and it was driving me insane because literally I just finished a section and then there will be announcements that it was being changed. So that drove me a little mad, but it's gone to the House of Lords at the moment, so it's gone a bit quieter. So I'll be having a look at some of that. Literally, I've probably got enough material that I could talk to you for 8 hours on this. I won't be. You'll be delighted to know. So I will try and keep myself on track, and Helen will metaphorically kick me under the table if I go off on too much of a tangent. National minimum wage and national insurance contributions. I'm sure everybody on this call is more than well aware of what's happening in April, but we'll have a quick look at that. And obviously Helen will talk to her area of expertise in terms of retention and attraction tips to try and keep everybody's business growing at what I think for employers are challenging / scary times at the moment. And whilst I can't say that I can reduce any of those, hopefully with a little bit of information and a bit of guidance as to how maybe you can start taking some proactive steps, I think hopefully we can reduce some of that for you. Helen, you happy for me to kick off, or is there anything that you were going to say that I have missed?
My silence is indicative of the fact you can go for it.
Fabulous. Okay, so it's obviously quite appetite to start talking about working from home, hybrid and return to office arrangements this week, when I think it was pretty much this week 5 years ago that certainly we at Dean Wilson were very much trialling, okay, let's just work from home for a couple of weeks and see how that takes us. And everybody was getting very worried about sitting on dining room chairs all the time, and they really weren't going to be comfortable, and how are we going to do this? And obviously the world moves on and everybody copes. But I think, there is very much signs of the pendulum swinging back from where we were 5 years ago, when everybody pretty much, or in a lot of industries, was working from home. I'm sure most of you will have seen the panorama that was on, it was probably about a month ago now, wasn't it? Where Stuart Rose was quite condemnatory, I think, about ongoing working from home and hybrid arrangements, and was very much advocating that everybody just needs to get back into the office. I think so. It's very much, it's a pendulum at the moment. The Office for National Statistics research in autumn of 2024, so sort of 6 months-ish ago, showed that 28% of working adults in Great Britain were working some form of hybrid working arrangements. So I think the pendulum has clearly gone from where everybody who could work from home was working from home, and it has certainly moved back into something more like hybrid arrangements. Obviously, there are industries where working from home just isn't possible. Hybrid arrangements aren't possible. Things like a lot of manufacture, hospitality, medical settings, things like that, working from home for an awful lot of people just isn't viable. But those and working from home and hybrid arrangements, they are going to be more prevalent, or they're found to be more prevalent in those aged over 30, those who are parents or have caring responsibilities, those who are managers or hold professional roles, and industries where there is less face-to-face contact required. Essentially, what the research has shown is that the more qualifications a person holds, the more likely they are to be taking advantage of working from home or hybrid working arrangements. So the arguments in favour of working from the office, certainly the ones that are being used at the moment, are, well, that's how it's always been done. And that was very much Stuart Rose's argument, I think, in that Panorama programme, which was, that's what we've always done it. So why are we now, why has there been this change? A need to get value for money from expensive real estate. Employers have got, in some cases, expensive offices that are going underutilised, and that can drive a desire to get more people back into the office. And then the argument that is very often used, which is greater cohesion within the workforce, will drive productivity for the greater good of the organisation, the economy as a whole, the country as a whole, all of those sort of arguments. The stats don't really back that up, I don't think. There was some research which showed that 78% of managers said that they had no difficulty managing productivity for remote teams versus office-based teams. So,
Claire, can I ask you a question?
You can.
So, just around this, I just wanted to ask you if you're seeing like the statistics played out in some of your clients, and because you're dealing directly with decision makers, are those decision makers expecting people to come back to the office? Because that's sort of what we're seeing with some of our clients.
I think there's some and some, to be perfectly honest. Certainly, the big drivers and the companies who seem to be mandating a return to office rather than potentially taking a slightly more flexible. They seem to be the very much the larger employers. So the Amazon, JP Morgan, although JP Morgan I think rode back on their very clear, we're all back in the office. BT, PwC, Asda, Santander, those are really large organisations. Certainly some of the more SME type of clients who I support, they're very much, we think that there are benefits, but are very cautious and wary about imposing any kind of significant additional requirements for office-based presence, because it seemed to be very unpopular with employees, and so could result in greater attrition rates and not being seen as being terribly attractive in the recruitment market. That's obviously something more that you're likely to see rather than me, Helen.
And I would absolutely agree. There seems to be a real disconnect between an expectation from employers for all the reasons that you've pointed out, and what candidates and employees want. So, and there's some companies that are doing it incredibly well and balancing it brilliantly. But there are other companies who, with that reticence about everything else that's going on in the market, they are not able to kind of see the wood for the trees. They're like, we want people back in the office. They must sit on seats and we must be able to see them, much like Stuart Rose was saying. But I think that there needs to be kind of something in the middle. So there's lots on the candidate side where the candidate market's very demanding. Like, I want, they've got dogs over lockdown. They've got other things going on. They've seen the benefit of working from home, as do we all. We all, like, I work from home. You work from home, Claire, sometimes as well. So it's a benefit, definitely. But it also isn't, it's seen by a lot of candidates as a complete right, and there is no flexibility within it. So for me, there needs to be some joining. So there needs to be some client softening, but also some candidate softening as well, so that we can all get everybody back out to work, particularly in a very tight job market, because we're in a very tight job market at the moment. Gone are the days where we didn't have enough people. Now, although there are jobs for people, it's a much tighter market that we're working in. So but then employers should not use that to their advantage either, because then they'll come unstuck when the market changes again, which it always does, and it becomes the candidate's choice rather than the employer's choice. So it's about balancing it for the long term rather than just looking at the situation we're in at the moment. I think we've all...
Certainly, my experience of talking to employers is their ability to persuade people to come back into the office at all / more is improved where you've got a clear and evidence-based rationale. So, for example, if you just say you've got to be in the office 2 days a week, 3 days a week, 40% of your working time spread over a month, however you want to present it, but then make it logical as to why they've got to be in at all. So I've seen anchor days work really well. So, for example, if within an organisation you've got a requirement to spend 40% of your working time in the office, if as a team it's like, okay, this team, everybody is going to be in on this particular day, so you can do things like team building, knowledge sharing, as opposed to you can come in, you've got to be in 2 days, doesn't matter when. And so you can literally be sat in an office thinking, well, there's nobody who I collaborate with who's actually physically here at the same time as I am, so I may as well just be at home. And I think it's that can reduce the perceived value of working in an office. So I think employers do have to work quite hard to make it an attractive proposition. So it's like, we want you to come in so we can communicate with you, so we can increase collaboration, which is all fine, but you've then actually got to enable that to happen. So I think it's more than just saying you've got to be in 3 days a week.
Thank you, Claire. There was a question, which I'm now trying to find. Oh, the joys of Zoom. Are there any legal risks to mandating people to come back into the office?
Potentially. First port of call always in answering that question is, what does the contract say? If the contract says you will work in the office and that is established as the place of employment, which frankly, an awful lot of contracts that were put in place before the end of 2019, that's what they're likely to say. Now, if that has been varied over the years, so, well, yes, that's what it says, but actually since whatever date it is today, the 18th of March 2020, I've worked at home. Is there an argument which says that by customer practice that has varied? There may be. So if you just say, right, well, as of Monday, you're back full time, could there be a breach of the implied term of trust and confidence and a potential constructive unfair dismissal claim? The claims arising out of the pandemic and coming out of the pandemic are starting to come through at first instance and at appeal level at the moment. So they're making some really quite interesting reading, or for employment law geeky people like me. Sorry, I'm sure not everybody is, but I find them quite interesting. So I think there's potential constructive unfair dismissal claims. I think there's potential indirect discrimination claims, either from people with caring responsibilities, with disability, additional needs, if they aren't getting additional consideration. So yes, I think there absolutely could be. It's certainly not enough just to say the contract says that that's your place of work, therefore you are back in the office full time. It's a bit more nuanced than that. And obviously, anybody who was issued a contract, say, beginning of 2021, and it's like, oh no, it's fine, you can work wherever you like because that's the new normal, and certainly that was people's views at that time, and so have therefore put a location clause in which says you can work wherever you like. You're going to there will need to be some more careful consideration in terms of how you amend that without causing potential difficulties.
Thanks, Claire. I think we need to move on to the next.
Do, because what the next thing that I wanted to talk about, she says, clicking over, because what I think the more employers are mandating a return to the office, could potentially see an uptick in flexible working requests. Now, flexible working, it's been around for a good 15, 20 years, she says, desperately trying to remember, can't really. It used to be far more constrained than it currently is. It used to be very much you could only apply for it if you've got children under 5, she says, desperately trying to remember. Should have looked it up before I came on this call. But it's eased over the years. So rather than just being seen as a right for people returning from maternity leave to come back on a part-time basis, which is what it pretty much was when it was first introduced, it's now open to any employee. From the 6th of April 2024, it's a day one right. So you can start your employment and pop in a flexible working request to change some of the terms and conditions of your employment, either the hours that you work, the place that you work. And that's where I think we may see growth. If we start to see more and more employers saying you've got to come back into the office and requiring that, you may get an uptick in flexible working requests. And the point, or the potential significance of that, is the change to that regime that is being brought about by the Employment Rights Bill, which is currently going through Parliament. So the current position is that an employer can refuse a flexible working request on one or more of the prescribed statutory grounds. So things like burden of costs, lack of available work at the required time, inability to reorganise the workforce, inability to recruit, detrimental impact on ability to meet customer demand. Now, these are all very subjective grounds. really. And under the current regime, if an employer says, I've considered your request to permanently change from your place of work to your home, I believe that that's going to have a detrimental impact on quality and performance, which are two of the prescribed grounds upon which you can refuse a request. That's the end of it. And essentially, if the employer has followed the correct procedure in terms of meetings, discussions, giving the right to appeal, they say no, it's going to have a detrimental impact on performance. That's the end of it. Now, the government are saying that they believe flexible working should be the default from day one, except where it is not reasonably feasible to allow that flexibility. And so what that means is the Employment Rights Bill is importing a test of reasonableness into consideration for the first time. And so still a requirement to request flexible working, but and the employer still only has the 8 specified statutory grounds upon which a request can be refused, but you will only be able to say no because we believe that there's going to be a detrimental impact on quality or performance or whatever the other grounds are, if it is reasonable for the employer to say that. And so there is a test of reasonableness that is now being imported. So an employer is going to have to justify, essentially, the grounds on which they say that they are relying to refuse it. So is it going to make any practical difference? I think it might do. It's certainly adding an extra hoop that an employer has to go through before they can legitimately say, no, we are not requesting, we're not agreeing to that request. If they've got reasonable grounds, then they've got reasonable grounds, and that's absolutely fine. But if it's just we want everybody back because that's what we want, you may have to develop your thinking a bit more.
That's great, thank you, Claire. And there was a question from Melissa: what happens if an employer doesn't accept a flexible working request? But I think you covered that in what you've said.
Well, if they don't accept it and the employee remains dissatisfied with that, they've got the right to internally appeal. If they get to the end of that and they're still not satisfied, there's a claim that they can bring to an employment tribunal for and so I think there will be challenges around what amounts to reasonable grounds for refusal. The potential difficulty from an employee perspective is that even if that claim is successful, an employment tribunal can't force the employer to accept the flexible working request. All they can do is award up to 8 weeks pay as compensation. And so there is some debate at the moment about whether the new flexible working, whether they've got enough teeth, or whether an employer is just going to say, okay then, sue us if you want to. The way the tribunal system's running at the moment, it would take a couple of years for that case to come through to a hearing anyway. So there is some concern at the moment whether that particular amendment will actually have that much teeth from an employee perspective. But certainly from an employer perspective, I think try and get your thinking developed, and so you can argue as to why your approach is reasonable, but then possibly just make the best decision, the decision that you think is best for in the interests of the business, and the consequences will take care of themselves. Sorry,
Thank you, Claire.
That probably sounds terribly cynical. Unfortunately, do this job for long enough and you end up that way.
I think we've got a question on SSP, but I think you're coming to that in a minute, aren't you? That's on our list. Yes, that is on our list.
Okay.
Oh, it's my turn now.
I get to shut up for a minute.
You get to have a slurp of your tea and a rest of your voice, because you're filling us with loads of information. So, as most of you know, I run Go Gecko Recruitment, and I'm also a partner in Consortium More Than Recruitment, dealing very much in the legal sector. And what I wanted to do, following on from that, I thought it was quite a good break to have recruitment and retention tips after we've been talking about work from home, and flexible working, and all the things that employers and HR professionals have to deal with on a daily basis with employees was to talk a little bit more about your people. So for me, recruitment always starts with retention. So it's very much looking at who you've got, what positions they're in, and also what they actually want, because I think a lot of businesses recruit people, they don't have a clue about what those people, why those people are motivated to turn up to work, what they're actually looking for. Do they actually want, is it just a job, or is it a job with some kind of idea of what they want to do in the future? There is quite often, it's very transactional and quick, like we need people yesterday, or we need someone to fill that gap, and there's a lack of maybe understanding and thinking around what motivates them and why they work for you, which is really where retention starts, and what attracted them to you in the first place. And we also do some psychometrics on teams. So we do psychometric testing on the individual, but also in relation to the team, so we can see where the team fits and where that individual fits into the team, which helps head off risk. So we're all talking about risk and where what people are going to ask for, what they're not going to ask for, but you can head off that risk if you know where that person is in their journey, in their career journey, and what they're actually looking for long term when they're working with you. And from the point of view of recruitment, so a few things that I've been thinking of, because I've been thinking, right, national minimum wage is going up, NI contributions are going up. For some businesses, it's catastrophic from a financial perspective, but you still want to grow your business. You still have gaps in resource that you need to fill. You still need people at the end of the day, because people are going to run your business, albeit that we could have that argument about AI and how robots are going to take over the world. But for the intents and purposes of this webinar and maybe the next year or two, we're going to go along the line that people are still really important in business. So my whole ethos about it is to not be transactional and panic about what you're looking at, is to have that forward thinking strategic approach, so that you're almost anticipating what's coming next, so that you can retain your people, but also recruit from a point of calm and be able to recruit really good people ahead of time, rather than looking at it from a point of panic where there may not be the people in the market that you actually want. They may, and you may have to take someone that maybe isn't the person that's right for the business or right for them even. So my ideas around that is flexible resource. So it's when you're looking at massive increases in salary bills and your NI contributions, etc., it's like look at what you need, and it may be that you can look at a flexible resource, and that could be a part-time resource, because actually you look at the hours that you need, and you don't need a full-time person, which brings your NI bill down on that person per head count. Or you might be able to do 2 part-time people, also looking at bringing your NI contribution down by looking at part-time rather than full-time. Also, I was talking to a pharma recruiter just now, actually, and she said that a lot of their clients, they're big corporates like Pfizer, AstraZeneca, etc. They are there, and she does permanent and contract recruitment, and they are definitely seeing a shift from perm to contract. So although contract is expensive, so don't go into this thinking, oh, it'd be much cheaper than a permanent person. Short term, yes. Long term, no. If you're looking for a long-term solution, contract and temp is not. It's much more expensive, because you are paying the agency or whoever you're bringing on. You're paying a contractor much more than you would pay a permanent person, because they're absorbing the risk. So they're absorbing the risk for you, so that you don't have to pay the NI and the tax, etc. They would be paying it. Or an agency, if you're taking on a temp, you pay the NI and the agency to do that role, but you have the flexibility to switch that tap off or switch it on again, depending on how long you're taking that person on for. So you might say, I'm taking them on for 10, 12 weeks. They would have the same rights as a permanent employee, but the risk is not with you. The risk is with the agency or their payroll provider. So you're not then absorbing that need to keep them on going if you've only got a project or a period of time where you're looking. So my whole ethos is about people at the moment is, let's be more creative. There are lots of people out there looking. There's lots of different ways of affecting your business and still being able to grow, whilst also managing the financial impact of what's going on externally. So there are lots of different ways of looking at the same thing, rather than just we need a permanent person and this permanent person has to be in this position. So and also it's having that strategic approach. So knowing your employment law, knowing what's coming up, knowing, you know, what your people are looking for. So for me, my tips to finish this section off are: know your people, regularly look at the gaps in your business, we're in line with your business plan and where it's going, so you can see where your people resource are and whether they're up to scratch, whether they need training and development, you know, what exactly they require. Recruit ahead of time so you can do it in a planned way. Be completely strategic and not transactional, and look at alternative resources to test what you actually need. So that is my bit. Any questions I can either take now or at the end, but I'd love some questions, so please come up with some. Back over to the employment lawyer, Claire.
Well, I was going to ask you a question, to be honest.
Oh, hooray! Thanks, Claire.
And it may be because I'm going to come on next, I think, to talk about unfair dismissal claims and the fact that the time period for continuous employment before somebody has the right to bring that claim to an employment tribunal is effectively going to be abolished. Do you see that as going to be a driver towards taking more people on through an agency to manage that sort of risk?
There's definitely a swing towards temp and contract, and I don't know whether that is because of, I think it's partly because of cost, because they're thinking, do you know what, we'll take someone on, they can finish the project and then we can move them on. What that does limit employers to people who are readily available in the market. So you're not looking at the passive people who might be dipping their toe in, who are already in employment. You're looking at the people who aren't currently in employment, generally with contract and temp. I mean, some people are professional contractors and professional temps, so that's what they do for a living. So I think, in answer to your question, I think the more tight that law becomes for employers, the more difficult decisions they are going to make about their people. And we very much specialise in the small to medium business space, and those are the people who are, you know, kept up at night about, you know, do they keep hold of that person? How long can they keep hold of that person? You know, do they look at an alternative? You know, so, and the fact that you know, an unfair dismissal claim can be brought from day one can be really worrying, because those people are generally not HR professionals, or, you know, a lot of small business owners they have HR consultants externally, but they don't necessarily know the law themselves. So it's it's very, very onerous. I don't think it will be a massive effect straight away until there's some examples of law and cases that have been brought. But I do think it's a consideration, definitely. All of this is a consideration.
Actually, what I'm coming on to talk about now is very much that it is just, I kind of feel it's getting a bit of a funnel. And the walls are, to a certain extent, closing in on employers. Now, you know, that absolutely, and was a manifesto commitment, I think, by the Labour Party to make work more secure for employees and to increase the protection offered to employees and workers. But there is a corollary to that, which is that actually it's tough for employers, or it will be, when all of this stuff comes in.
And I think that I think we'll come to it later on, but it's knowing good partners to have to support you is really critical, because your knowledge is, you know, so extensive, and you, as you said, you read the law all the time, so you know what's coming up, what's changing, which a business owner, or, you know, and even an HR professional is dealing with the operational side of things day in, day out, is not going to have the time or inclination to be able to do it. So I think it's also, with all these things, it's like having a really good accountant that knows their stuff around the finance stuff, having a really good employment lawyer, having, you know, a really good contracts lawyer, like knowing who you can turn to ask for support is really important, because there's no way you can know all of this yourself. Not a chance. So
Not unless you want to be a geek like me. Right.
we love that you're a geek, because then we all get to know what to do next.
Okay, let me rattle a bit through day one unfair dismissal rights. So at the moment, an employee must have 2 years continuous service with an employer before they have the right to bring a claim to an employment tribunal to say that they've been unfairly dismissed. Now, what that means in practice is if an employer has an employee with less than 2 years service, they can either choose to go through an abbreviated process before giving notice if you've got a conduct issue or performance issue, or in fact there's a redundancy sort of situation. You can an employer can cut corners isn't the right word, but you know what I mean. As in, that they can adopt a more pragmatic view to things, in the knowledge that unless there's some form of discrimination or potential protected disclosure under the whistleblowing legislation, the employee's ability to bring a claim based on that termination is limited, essentially to what notice they're entitled to under the terms of their contract. That is seen by the government as being potentially stifling of people moving around in terms of jobs, because you have to work for a fair chunk of time before you acquire employment protection rights. And it's thought that actually people moving jobs more frequently could act as a boost to productivity. So, what the Employment Rights Bill will do is abolish the current 2-year qualifying period. Now, it's been a bit of a political football, she says, because just as I qualified in 1999, really quite a long time ago now, the qualifying period, it had previously been 2 years. The incoming Labour government, well, it had been in power for a bit by then, reduced that to 1 year. And it was at 1 year until 2011, 2012, something like that. So certainly once the coalition government came into power, it was then increased back up to 2 years again, and it stayed there until now, when the idea is that the qualifying period is just going to be completely abolished. The right to claim unfair dismissal will apply from day one of employment. So if an employer doesn't either have a potentially fair reason for dismissal or doesn't follow a fair process in deciding to dismiss, then the employee would have the right to bring a claim of unfair dismissal to an employment tribunal. There is the proposal, and it's all going to be fleshed out in regulations, so there is no detail about it in the draft Employment Rights Bill, so I can't actually tell you what it looks like. But the proposal, the intention is that there will be a light touch dismissal procedure which will apply during an initial period of employment. The obvious questions arising out of what I've just said is, how long is the initial period, and what does light touch mean? I wish I could tell you. There's discussion that the initial period could be 6 months, could be 9 months. Light touch could mean a requirement to have one meeting with an employee to say, we don't think your performance is good enough, or actually your conduct isn't acceptable, before dismissal. There's also some discussion about that if you did dismiss during that initial period of employment and that dismissal was subsequently found to be unfair, then a lower level of compensation may be available to the employee, as opposed to those who were outside that initial period of employment. But it's all very vague at the moment. What I can say, and what the government keep repeating because they don't want to scare employers away from recruiting, is that none of those changes will be implemented before the autumn of 2026. So the idea is that the bill will I'm assuming will pass through all of the parliamentary stages within the next couple of months, will receive royal assent, and then there will be further consultation both with trade unions and with employer organisations, and then there will be draft regulations, and so we will know. And the idea is that employers will have sufficient time to prepare for what is likely to be a fairly large change before it comes into force. So what I absolutely think is that this is going to reinforce what I and other employment lawyers and HR consultants emphasise all the way through. It's the importance of probation periods, which is you get somebody in, actually spend some time in those first initial months reviewing, are they a good fit for our organisation? Have they got the skills, knowledge and experience that we are looking for? Do not leave it until 1 year and 11 months, which I'm going to say a lot of my employer clients do, but it's not unheard of that I get a call literally as somebody's just coming up to 2 years saying, yeah, they're no good. We just need to get rid of them. You're going to have to do it a lot earlier. So getting a proper performance management framework in place and then following it, I think is going to become more and more important as that change takes effect.
Can I ask you a question, Claire? I was aware that they were looking at changing the probation period, like from a legal perspective. Is that right, or is that happening, or not? You don't know?
Don't know, because there's no actual reference in the bill to probation periods. There's this initial period of employment. Ask me to define what the difference between a probation period and an initial period of employment is, and I can't do that. So I don't know is the honest answer.
Okay. We will wait and see.
Wait and see, watch this space, as they say, but take some comfort from the fact that we seem to be 18 months away from it actually kicking in.
Thanks, Claire.
That's all right. Just picking up then on, and I absolutely agree with what Helen was saying in terms of, that employers can investigate different types of relationships with their workforce. So 0 or low hours contracts or using agency workers. Absolutely the right thing, and you can keep on top of you can potentially manage your risk greater, and certainly manage your financial exposure. There are some changes contained within the Employment Rights Bill which will have an impact on that, and it's one of the changes that came through as a result of the third reading debates in the House of Commons last week, which was because all of these proposals, when the bill was first published, just applied to 0 and low hours workers, and then last week they said, oh yeah, no, it's all going to apply to agency workers too, which is one of those, you blink a couple of times and think, wow, that's really quite significant. So what are the headline changes? There's a lot of detail, but we'd be here for the 8 hours. I'd be delighted, but just keeping us on track somewhat. So what's going to change? Workers are going to be entitled to compensation if their shifts are cancelled or changed at short notice. What amounts to short notice? Don't know, to be specified in regulations, which is now going to be my theme tune. But what it's likely to do is mean that if somebody thought that they had a 10-hour shift and they're told starting at 9 o'clock in the morning and they're told at 8 o'clock the night before, actually, we don't need you, don't bother coming in. And obviously, because you're on a 0 hours contract, you're not going to get paid. Then they will be entitled to compensation. What that compensation looks like, whether it's going to be the full what they would have earned for all of that shift or not, again, that is to be specified. The extension of that right to agency workers, agencies are going to be able to recover that. Just letting somebody in. Are going to be able to recover any compensation that they are obliged to pay to their workers from the employer, from the end user, if it's the end user who's given the late notice. So that's one aspect. The other aspect is going to be that if a worker, either one who's engaged directly by the end user employer or through an agency, if they have a relatively stable, again, to be defined in regulations, working pattern over a reference period of which looks as though it's going to be 12 weeks long. And so, there's some variations, but generally their working pattern is relatively stable. At the end of that reference period, the employer is going to be obliged to offer to the employee or worker a contract which contains guaranteed minimum hours. And so it's not that the worker or employee has the right to request that contract. The employer is going to be obliged to offer it to them. And it's not just going to be a one-off offering, it's going to be at the end of every reference period. So if, as is currently suggested, the reference period would be 12 weeks long, the employer, the end user, or the agency, if they're engaged through an agency, is going to have to be monitoring it, know what the minimum hours, which will be specified in regulations, is, and if the working pattern has that sufficient stability, they are going to have to continue to offer that contract with guaranteed hours in it. So the complexity and the burden that this is going to place on employers, end users, I think at the moment there is significant concern that is really quite a lot of a burden that's going to be placed on employers. It may very well change either as a result of, as I say, it's just gone to the House of Lords now, so it may still change before the Act receives royal assent, or it may change in regulations which it will be required to implement this in any event. I
was going to say, it sounds very similar to, so when the 12-week AWR period, where employees are entitled to the same, temps are entitled to the same benefits and etc. of a permanent employee. It sounds like a bit of an extension of what that legislation has done for temps. I mean, we don't deal in 0 hours contracts, but we do obviously deal with agency side, and it tends to be a refill of it tends to be a similar role to something that's already permanent in that company anyway. That's our experience of it. But I personally don't think it's a bad thing from an employee point of view, because I think there's lots of people in hospitality and lower end jobs who are really severely messed around on a regular basis, because employers use that as a way of just filling in when they can, but it does have a financial impact for those employers.
What I think it will do is reduce the attractiveness to an employer of just engaging people on 0 hours, actually in practice giving them pretty stable hours, but knowing that if they can't, then they can just cut it and say, well, no, we don't need you next week, therefore we don't have to pay you. I think it will remove the ability to do that if generally it's all pretty standard. So if this is implemented in the way that it is, the record keeping and the administrative requirements on an employer are really very complex. There's some advocating a sector by sector approach. So it may be that different rules apply to things like hospitality, maybe potentially agriculture, that sort of thing, as opposed to less peaks and trough demand sectors.
I think that would probably be quite wise from the point of view of those sectors already finding it challenging after Brexit, when a lot of their normal, seasonal staff left the UK. So yeah, it'd be interesting to see what happens from that.
I'm conscious of time, and so
Yeah.
I'm just going to rattle through the next couple of points, but very happy to take questions either as they arise or at the end. Statutory sick pay, this is actually one of the changes that may come into force relatively quickly after royal assent is granted to this bill. Most of these, where I've said, oh, you know, it's all to be determined in regulations, that's essentially kicking the ball down the line, I would say, for at least 6 months from here, if not more. But some of these SSP changes may kicking it in earlier. Absolutely. The first one is current rate of SSP is £116.75 a week. That increases just as a result of the normal annual increase up to £118.75 from the 6th of April, because obviously we're just coming into end of the tax year. So current regime, as I'm sure you're all aware, forgive me for teaching you how to suck eggs, first 3 days of absence is unpaid. Thereafter, entitlement to be paid at the statutory level. Those who earn under the lower earnings limit for national insurance contributions, which is currently £123 a week, going up to £125 on the 6th of April, aren't eligible to receive SSP at all. So the real lowest paid workers in the economy don't get statutory sick pay. Changes to be brought about by the Employment Rights Bill are that the 3-day waiting period for SSP is going to be abolished. So SSP will apply from day 1 of absence. Now, in a lot of cases, employers will pay contractual sick pay from day 1. But again, it tends to be down at the lower end of the economy where it's just SSP, and so therefore no entitlement for the first 3 days. That's going. And if you earn under the lower earnings limit for national insurance, so £123, £125 a week, you are going to be entitled to statutory sick pay, which if you do earn under that limit, you won't be entitled to SSP as such, but be entitled to receive 80% of your normal earnings by way of sick pay. Must be said, that makes me a little queasy, the whole 80% of normal earnings, because that's just furlough pay, and yeah, it triggers me a little bit. But there we go. So again, I think good news for the lowest paid workers in the economy. FSB have voiced some concerns about the cost that's going to impose on smaller employers. Obviously, a lot of SSP is recoverable from the government, but it's administrative burdens, cash flow, etc. So that's coming. The removal of the lower earnings limit, that will require substantive regulation, so I don't think is likely to come in. I think there's likely to be sort of 6 months-ish, she says. I hope it's a bit finger in the air, but that's my educated guess on that. The removal of the waiting period, that only requires commencement regulations, and so that bit could come in relatively soon after royal assent is granted. So I think it's very much a watch this space point on that removal of the waiting period. You said there was a question about SSP.
Oh, yes, I need to go back up my questions. When will the new rules on SSP come into force? That was the question.
Yeah, I've answered it already.
Beautiful.
Perfect. Moving on. Okay, very quickly, A, because I'm sure you're very well aware of it, and B, because we're running out of time. National minimum wage increases. Now that's the 1st of April, and I always have to double check all of these. Is it the 1st of April or is it the start of the new tax year? And it varies. So national minimum wage, that's going up from the 1st of April. Headline rate, so that's for those aged 21 and above, £12.21 an hour, up from £11.44. Quite a high percentage increase at that level. And the other rates, so 18 to 20, that's going up to £10 an hour, up from £8.60. 16 to 17-year-olds, £7.55, up from £6.40. Again, these are bigger percentage increases for lower paid workers. Apprentice rates, £7.55, that's up from £6.40. So those additional costs coming through from the 1st of April. Changes to the national insurance contributions, that's the one that kicks in 6th of April because it's the start of the new tax year. And so that increases the employer rate of NICs from 13.8 to 15%. And you start paying national insurance on lower earnings and pay it at a higher rate as a result of those changes. But there is an increase to the employment allowance from 5,000 to 10,500, and the idea is that supports smaller employers cope with that additional NI charge. There we go. Unless anybody's, well, no, this is absolutely your time to ask me or Helen any questions you've got, either based on what we've been talking about this morning, or in fact, you've kind of got us for 4 minutes. I mean, it's a hostage fortune, isn't it? You can ask me anything you like. She says, thinking, wow, I hope I know the answer.
There was one question. Are there any steps which could be taken now to prepare for the changes in 0 hours and low hours contracts?
My big tip for this is audit what contracts you've currently got. If you've got people on 0 hours, actually monitor them, say over the next 12 weeks, and see actually what fluctuation there is in their hours. Work out, okay, well, that's 12 weeks from, towards the end of March. Actually, are there other periods of time in the year when there are really very significant fluctuations? If you've got people who are on 0 hours or low hour contracts, that actually it's not relevant because they're working pretty stable hours, I would say get them off that contract and just put them on a guaranteed contract anyway, because you're going to have to, because that's what the law will require you to do. And so I just say get ahead of the game. Obviously, if it is a genuine 0 hours contract, as in there is constant fluctuations, then so irregular hours, then that's what those sorts of contracts are designed to do, in which case keep going. But if it's just you like the certainty of, well, no, it's okay, they're only 0 hours, and so we can just not give them work if we don't want to, I think that's an area that I would have a look at.
Thank you, Claire. Any other questions? You can unmute yourself to ask questions if you'd like to. We've got about 3 minutes remaining. And what Claire and I are going to do is offer a free 30-minute chat for anyone that has an issue they want to talk about, or more information that they want. We're open to booking 30-minute consultations for free with any of you. So if you have got questions that are burning, for me about recruitment and retention, for Claire about any employment law, then we're open to that. Any questions at the moment in the last remaining minutes? No?
Okay,
right.
Well, thank you for coming.
Thank you all for coming. And I hope you found it useful. We will be probably running an update on, because this legislation is ongoing and changing, isn't it, Claire? It's not in that, some of it has not been completely ratified yet. So it may well be that we run another wrap up in the autumn as we get towards the end of the year, so that you can log into that as well. So there will be more information coming from us, and we'll be sharing the video with all of you, so that we might edit it a bit first, but we'll be sharing it all with you so that you can dip in and dip out if you've missed anything. But we'd really like to thank you all for coming. And if you know anyone who would like the recording as well, please let us know, and we can then send it on to them as well. Any final thoughts, Claire?
No, thank you for coming. I'm I'm saying autumn for an update might be a bit soon because literally you don't want to hear me say again, well, yeah, it's to be determined in regulations and I can't tell you what the regulations say. So it may be a little bit later than the autumn. It won't be that we've forgotten about you or that we're not going to do it. It's just going to be until we actually know a little bit more. We may hold our horses, but you've got both of our contact details. So either now or in the future, you know where we are.
Take care.
Have a
Bye.
lovely day, everybody. Take care.
Bye.